Welcome everyone to today's episode. If you run a business in India, whether as a CEO, founder, CFO, or a general counsel, you already know that compliance is no longer a back office function. Instead, it's a strategic priority. And among all the compliance obligations, TDS, which is tax deducted at source, sits right at the center of government scrutiny. But here's the surprising part. What most business see it as a routine monthly task can soon turn into a criminal prosecution. And if it's not deducted or deposited correctly. And over the last few years, the income tax department has shifted gears. We have seen more show cause notices, more court filings, and way more aggressive enforcement. So, this raises some of the big questions for every business leader. What triggers prosecution? How do courts look at TDS defaults today? Can the directors or the finance heads be held personally liable? And more importantly, how do you protect yourself and your company? To decode these questions, we have with us two of the leading experts in tax litigation who have handled some of the most complex, tedious prosecution matters, Advocate Vivek Sareen and Advocate Shreyas Srivastav. Introducing our guest, very warm welcome, sir. Uh, Advocate Vivek Sareen is a leading tax expert who has handled disputes in regulatory and commercial disputes with over 20 years of experience in representing clients before the top judicial bodies, including Supreme Court of India and various high courts. He's also the founder of Commercial Law Chamber and has been a leading counsel in a lot of organizations. That's how he brings a lot of deep insights to the legal approach and advocacy. And with joined with him is Mr. Shreya Srivastav. He is an alumnus of HNLU and has over a decade of experience in handling litigation pertaining to insolvency, regulatory compliances, etc. Again, a very warm welcome to both of you.
Thank you, Swagata, for having us on this occasion. Um, Good morning to all of you.
Right. So, to begin with our questions, what we are looking at is right now, how does something which is more of a routine compliance task turn into a criminal offense or results in criminal prosecution?
Okay, so there are two things which are very important. The first thing is that it is the mechanism which is devised by the income tax department, or say to say by the parliament, that the tax has to be deducted from the source from where the money is coming from a company or a service recipient or the purchaser of the goods or in any other form, whichever is considered to be the transaction for which the TDS is made compulsory. So they want to deduct the advance tax before it goes into the hands of the payee or the recipient of the money. Subsequently, when the recipient of the money, which is the payee, when he files a return, that this advance tax is adjusted. So that is the first requirement, which obviously has a very important function of meeting the budgetary aspects of the country. Number two is that the reporting requirement, that the whenever the TDS is deducted, the transaction is immediately reported, because the payer has to report that transaction into the return which is supposed to be filed by the company. So these are the two important functions. So that one is the second aspect is that even if the transaction is there, in case the TDS is not deducted, of course it will not be deposited also, then the transaction gone unreported, and that is not a very beneficial situation for the department also, and from the income tax perspective as well. So both of them are important. That one is that to deduct the tax in advance, and secondly to report the transaction to the government. So these are two important things. So therefore, the compliance is very, very important, necessary, and default in compliance may lead to various consequences, which can lead to assessment, penalty proceedings, and the prosecution also, in case the default continues even after the assessment order.
So, from what I understand, it does not become a criminal prosecution at the very early stage itself. It has a process from where, how do you trace what are the red flags in being non-compliant to, like, what is the journey of being just a mere default to it being a criminal offense?
Okay, so now we look at the legislative framework. the legislative framework of Chapter 17, which is the chapter which is devoted to TDS in Income Tax Act of 1961, it says that when there is a default, so default could be of two kinds, where there is a situation A, which is non-deduction and non-payment to the government exchequer. Number two situation where there is a deduction but non-payment to the government exchequer. Now, the first situation is not that severe. Second situation is considered to be very, very severe, and it is taken very seriously by the government. So that is one. Now, what is the practice right now at present is that they don't want to, there is a procedure prescribed. The procedure is two-step. One is that you undertake the assessment under 201. You undertake the penalty adjudication under 221. And in case in both the step 1 and step 2, you do not comply with the provision and you still remain in default, you go to 276 capital B. And in case 276 capital B, you still do not do anything, then it goes to 279, where the sanction order is passed for the prosecution. Now, but this is not the system which is followed. They straightway go to the process which is called the officer responsible, which is 204. So there is a, the entire scope is defined, that who, along with the company, who could be the person who can be prosecuted, because the company cannot be jailed, company can only be fined. So the person responsible has to be punished by way of imprisonment and fine and other things. So now any person who is connected with the management is considered to be principal officer, he will be prosecuted. So generally what they do is that they issue the notice 204 read with section 2 subsection 35, and they decide about the person responsible. So they generally issue the notice to every person who is sitting in the board of the directors. So suppose 10 or 15%, they issue everyone. So everybody then thereafter rush to the department, submit the document saying that I'm not the person who is connected with the management, I'm not the person responsible for the TDS compliance, and so on and so forth. So in that situation also it happens that the independent directors are also sometimes caught into the crossfire. So that is the process they take. First step, thereafter they issue show cause notice for 276B oblique 279, and then they take the reply and issue the sanction order, and straight go to the prosecution, and they file the criminal complaint, which is a private complaint filed before the CMM court in any of the jurisdictional area. Now, the process should have been different. Process should have been that first you assess the person, whether the person is in default or not.
Right.
And in case he's in default, because the default can lead to two situations, that his liability, so far as the areas of tax is concerned, that is determined. Number two, delay is also determined. And then penalty is also determined, because that it will move along with the 221 also. But that doesn't happen most of the time, because if that happens, but there are situations where they have undertaken that 201 process and 221 process, and the person had deposited and complied with the provisions and deposited the tax along with the interest, which is 1% and 1.5% for each month. So that's quite a heavy, you'll say that the interest rate, which is 12% to 18%. And the penalty amount is also equivalent to the tax amount. So even if somebody complies with that, they still go ahead with the prosecution. Now, this has been an issue for debate all across, and there's a serious contention around this particular aspect. So
right, because what I understand, it's more on the line of a compliance default, right? So it does not it's very alarming for the people who are the business leaders that this can be a criminal prosecution at a later stage or at some stage of the process. Mr. Shresh, what do you think? Do you think having a criminal offense element in this entire process at all required? Because like all other compliance issues, not all issues result in a criminal offense, right? It can be rectified. This is something which can be rectified. So in such a scenario, is it really required to have the criminal offense element in this entire process?
Thank you, Swagata. So the criminal angle comes in from the perspective that the amounts which are collected or which are deducted by the payer, right? What happens is these amounts are collected as a custodian of the government, right? And what happens is that if you do not pay this amount, or for an example, you are supposed to deduct this amount, you do not deduct this amount, then in that situation, what is happening is there is a default on your part which is affecting the government directly, right? And the amounts which are honestly being collected and not being paid to the government, it becomes an even graver offense, because there's a criminal breach of trust, because you're holding that money in trust for the government, right? And then you have to pass it on to the government. So obviously, if you look at the law from a criminal perspective, obviously, these situations do amount to criminal breach of trust, right? So instead of prosecuting a defaulter under the regular provisions, obviously a specialized mechanism has been developed under the Income Tax Act itself, which is a code in itself. So the prosecution under Income Tax Act is definitely comparable with the prosecution which happens in, let's say, any business transaction where there is a criminal breach of trust, where three parties are involved and one party defaults on account of the trust that has been placed on them, right? Then in that situation, prosecution is possible in such business transactions as well. So similar is the situation in this income tax provision as well. So I think the criminal angle comes from that perspective, right?
Right. Now it makes a lot of sense why the criminal element is there at all in the first place. But from what I understand, the issue show cause notice that gets issued, it gets issued against the company, right? So why is there a possibility that the directors, investors, or individuals in their individual capacity can get summoned as well? Because it should be against the company, because company in itself is an entity and a person. So why is it that there is always this the mindset that, not the mindset, because there has been situations where the directors have been personally been summoned. Why is that the individuals are targeted rather than having it against the company as a whole?
So I think the aspect of officer in charge concept, it comes from the Companies Act itself. If you see there, if there are defaults which are accountable to a company, ultimately it is the person who's running the company. It's a juristic person, but it does not exist in reality, right? So because the person who's driving the company is responsible for the actions of the company itself, and the Companies Act itself holds person in charge for the actions of the company. I think it's very logical that obviously there cannot be any other person who can be held responsible. Now obviously there are various departments, divisions, there could be multiple executive directors, each director having their own responsibilities. So identifying that particular person is the key to determining who's responsible for all of it. Like, for example, there are other various specialized legislations, let's say, for example, FSSAI or drugs and cosmetics. Under those provisions also, there is a specific requirement of designating a person who would be responsible for the defaults which are happening under that provision. So I think again it is comparable to those provisions as well, right?
Right. Mr. Vivek, sir, if you would like to throw some light on what does the law specify on who is the person actually responsible for some defaults? Is there a mechanism in place to know who is causing the default? The fault is at whose end? And because how do courts identify who to summon in that case?
If this question has to be answered from the perspective of a tax officer, so the income tax department immediately looks at the person who signs the return, the quarterly return of the income tax, and that is the first person which comes to their mind. That is one. Number two, who is the managing director of the company? That is the number two person. And the other directors who are in the executive position and shareholder directors, they come immediately on their mind. And that is how they do it. And the process which undergo to decide that who is the actual person responsible, there could be one or two person responsible, not entire board would be doing this compliance. So they are required to issue a notice, and there is a specific provision which is called 235, 2 subsection 35. and which says the person responsible in the case of company. So they have defined this term very broadly in a way that who is connected with the management of the company. So
So
the word
even if,
connected with the
yeah,
management
sorry
of
to
the
cut you.
company means, no, it's all right. Management of the company means that any person who is responsible for the conduct of the business, that could be the person responsible, or the principal officer of the company. It could be CFO. That is surely, yes, CFO comes as also one of the first target, and the tax head also comes as second target. The real problem arises when there is a expatriates who are sitting on the board and they are not in India. They have not they're not aware about the TDS compliances, but they are also made one of the parties, and it's a
Right.
very frequent situation. This is the mechanism. The law expects that the entire adjudication process of the order of 235 should be very fair and reasonable and judicious. But at times it is judicious and fair, and at times it is not so. Then you have a remedy, subsequent remedies for that.
This is the question that naturally came to my mind, that what if there are some individuals, ideally, if you are running a business, you are supposed to know, but a lot of times people do not have the knowledge that such default has happened. So even in such a scenario, can they be held? Like, how is it relevant whether they have knowledge of the actuals happening or not? Like you mentioned, that board of directors who might not even be aware that such default has happened. So does that play a role? Can that be used as a defense? If you could, like, give us some real life cases that you, or scenarios that you have come across where such similar situations have occurred and taken place.
Yes, so that plays a role, very important role, and there's a specific provision where there's a prosecution of the company. So the test is similar to other legislation which Shreyas has just mentioned, that there could be Negotiable Instrument Act, which is check bouncing cases. There could be Food and Safety Act, Drugs and Cosmetics Acts. So, and in some of the acts, there is a provision that you can make a person responsible as nominate a person, and like similarly to the Weights and Measures Act. But in some of the matters, some of the legislation, there is no such provision. So you can nominate somebody who is the person responsible. Now, that is where here comes the question that if I am not the person responsible for the compliance of that particular issue or TDS compliances, then whether can I be prosecuted in the court or not? Now,
Right.
then I have two remedies in case that comes. One is that I have to represent at the stage when the proceedings under Section 2, subsection 35, read with 204 are going on. I represent myself. And in case I'm not happy with that, then I have to take immediate remedy against that. I may be unconnected person. So, for example, that I'm a lady who is only shareholder. Because of my shareholding, I have appointed myself as a director because I have more than 22% shareholding,
Right.
and I have no other business because the management control is not there, and I do not participate in the day-to-day affairs of the company. And I'm sitting somewhere outside country, and
Right.
whether I could also be prosecuted. So question is, yes, notice may come to you or may not come to you, depending on the wisdom of the tax officer. And if notice comes to you, you have to represent yourself there. And in case you're not happy with that order, then you can take a subsequent available remedy, whatever remedy is available to you. You can approach the High Court also. And in case this stage is already crossed and your answers are not, or reply is not accepted by the tax officer, and he files a criminal complaint against you, then now here in the new CRPC, there's a provision that before issuing the summons, you can represent yourself once again. So there's a hearing opportunities to be provided before issuing the summoning. It is different from the previous one. In the previous regime, in the CRPC, the accused is not to be heard. Now, accused has to be heard before issuing the summoning order. Then that is the second stage you can do it. And in case you are not successful there, you can go into revision. And in case you are not successful in revision, you can go into 480 quashing petition in the High Court. So that is how it can go further. And similarly, in case the sanction order is passed where your name is also appearing. In 235, you are unsuccessful. 276, you are not able to satisfy. And 279, 276, you are not able to satisfy the tax officer. Then you can challenge the entire proceeding before the High Court in a criminal writ. So that is also one of the remedies available to you. So instead of
Right.
waiting for the criminal complaint to be filed and then going through the entire process, and when you are very sure that you have not participated, not responsible, and the documents are also supporting you, then you can take that remedy.
So, under section 279, there is a phrase called the sanctioning authority. So, is it the tax officer himself, or who is the sanctioning authority, and what weight does it play? Like, is it just a filter, or does it have some actual weightage in deciding as to who would be responsible or summoned or things like that?
See, so far as 279, the sanctioning process is concerned, that uh, the person responsible is decided prior to that, before the proceedings come to the stage of sanctioning.
Got it.
And though the law does not require that before passing the 279 sanction order, you have to hear anyone. But then what department does on the practical side is different, that they issue the show cause notice and they take your version and they reproduce that version and say they are not satisfied with the version in one line, and then they decide it, so that nobody can question them that you were unfair and arbitrary in your process. And that's how this modus operandi of them.
What are some of the real life situations you have faced where this has come up?
Yeah, so in the real life, they will issue the show cause notice. You will submit your reply. So the reply at 279 stage is that there is a reasonable cause on your part that you could not deposit the amount within time in case it's a delayed payment situation. Only in case of delayed payment situation, I emphasize that particular aspect. In case you are in default, then you have no remedy. You have to go into the prosecution. There could be various situations where they can accept. So mostly they look at, even if you have gone into insolvency, they don't care. Though the law says that the insolvency situation or the financial difficulty is a very valid ground. It's a reasonable cause. It is not a
Right.
sufficient cause. It's a reasonable cause. Means
Right.
only you have to assert. Your assertion is sufficient. Like, accountant who was supposed to comply with that was unwell. Accountant, he was out of country, is a sufficient ground. So these are the situations where they should accept that, which they generally don't, because they have their own difficulties. So they pass the order and then the entire process starts. So in real life situation is this. There are hardly any situations I have seen where they have not gone to the prosecution, or they have not gone to the compounding, because the compounding is also possible. So the
Right.
person, mostly in a situation where they feel that the company has a lot of money, where they don't have any financial difficulty, they immediately compound it. So compounding fee is also very heavy, approximately 3% right now. There's a change in the system. So they pay the compounding fee and then they close the matter off. So the only way they can bring them to the compounding is that they issue the sanction order, because they know that the now prosecution is imminent. So this is the real life situation where your reasonable cause is not considered and not accepted. In one line and one stroke, they say reply not found satisfactory. That is a standard line.
Right. That is very insightful, honestly, to have an idea as to what in real life gets considered as a legitimate excuse or not. If Mr. Shresh could also give us some insights about what are the real life scenarios look like. Also, what does the usual approach that court takes? Is it like does it look at it as a technical lapse, or does it prefer looking at the substance over the technical lapses? How does the court view it today?
So again, from a perspective of prosecution, when it reaches court, right, what happens is that there are so Vivek sir obviously explained us that there could be multiple remedies at different stages. Now we've seen obviously up till 279 there's rarely anything that we show that goes through, right? So when it reaches the court, let's say the special courts that are set for prosecution under Income Tax Act, generally what happens is these are extensive trials, right? And you do not have an opportunity until unless the trial starts to show that you are not in default, or maybe there is a reasonable cause, or maybe something like that. So that is why there are other remedies where the summoning order is issued, so we go for revision, which goes to a higher court, and then there is obviously the provision for quashing, right? So there the approach is way more reasonable, because these revisions or the writs that we file, they go before high courts, and high courts they look at it from a more equitable perspective rather than in a mechanical manner where simply because a person is in default, they should be prosecuted. That is not the approach. The reasonable cause there is determined in a more favorable manner to understand all the circumstances, because businesses face cash flow implications every few months. There could be cycles, every year, there could be cycles every 6 months. So maybe we have come across multiple judgments where the courts have identified these practical problems and understood the issues that businesses face on a day-to-day basis. And obviously any kind of criminal action relies on mens rea, right? So long as we are able to justify that there was no intention to non-compliance or to evade the taxes, I think courts generally are receptible, right?
So even though it's a grave offense, the court, what I understand, do not take a very stringent approach to while going through these cases. They do look at the what goes behind the scene as well, what's affecting the business and how it's like, is from what I understand. So how do you think that this impacts the reputation of the business? Like, is it very common, or is it like it's something very grave? How do you think it stands today in terms of the when it comes to the reputation of the business?
I think one of the reasons that we are having this podcast is because to tell the businesses that yes, prosecution is happening very frequently, and that they are not
Yes.
taking it very seriously, because we have come across, in fact we come across prosecution cases every day, right? And it is only when somebody has been issued a summoning order that they realize that okay, this was a graver default than I thought, or that non-compliance that I did was not as easy to go by than any other let's say not filing of return or something of that sort, or maybe delayed filing of returns, delayed filing of payments, and stuff like that. But again, I would say the approach of the government is also changing a little bit. As we see, the TDS prosecution provisions are fairly old, right? And as Vivek sir pointed out that the ecosystem in a economy which was not globalized, the ecosystem was very different. Now the ecosystem is very different. Businesses also have understood that compliance of law is very necessary. They have set up departments which are completely focused on compliance with different kinds of legislation, including
Right.
tax legislation. So we are changing that. We are seeing a change in the approach of the businesses as well as the government. So I think while I'll say that smaller businesses still face these challenges, bigger businesses are for a major part are compliant with the laws.
So
Has
I
it
just want to
become? Yeah,
sorry,
sorry, yes,
I
please
just
go
want to
ahead.
add one important aspect which Shreyas just mentioned, that the government has actually brought a very progressive amendment in last year in October 24, that they said, they added one more clause to say 276B, saying that in case you have complied with the return filing, uh, then your prosecution would not happen. So that is also one very progressive uh, move. Now, why it is so important that you can file the return once you have remove your default. Means that you have made the payment of the defaulted amount, you made the payment of penalty, you have made the payment of interest. So all the three components have been paid. So that means there is nothing to recover from you. So once it is nothing to recover from you, then in that case the statement is filed, there is a section which is 200, and under that, a statement which is a return which is to be filed. So you have filed the return. So now thereafter, you may not be prosecuted. So that is the new progressive amendment which has been brought in. So now there could be other issues relating to that, but that is for the future to see that.
Right. So has there been an increase in the number of defaults or show cause notices just because with the automation and data analytics, it's easier to flag it nowadays because nothing is manual anymore. So do you think that has resulted or impacted in the more number of cases as well?
You know that when you file the statement under 200, there is a 201 section 1A where they do the processing. So it is a summary processing, like a CPC, which is the automated system. They look at the software, looks at your statement and they process it. They feel there is a default, they immediately report or flag it. That's how it works.
Got it.
So of course, there is a benefit of the technology available to the department.
Right. And as you mentioned that the government has reformed its mindset and the approach to this kind of issues by letting them pay the amount at a later stage, file a return, and then safeguard themselves basically. So can it be looked at as something that, let's say I am a founder of some company and is it okay if I think that, yeah, let's have a default, I'll anyway pay the amount at a later stage and I am still safe? Like, is it something that I can rely on, or what mindset or approach should I have as a business leader who is running the business?
Alta, the important thing is that assuming a situation where the business person, a person who is running the company, if having the cash flow positive, then he would not like to make a default, because that default is resulting into a very heavy interest. That interest is 12% to 18%. So why would he want to have the 18% interest burden himself? So he would not like to make a default, even if suppose the default has occurred because of the cash flow was negative. Then he can pay the interest and the fine and make the payment of the defaulted amount, and then can file the return. So that's how he would not be prosecuted given this amendment of October 2024. Now, situation was also similar prior to that. It's more of a clarificatory which has come now. It is quite soothing and supporting to the companies, because of the various issues the company may not be doing well during certain times, so it's all right. So
Right,
they
that
have
makes a
reduced the
lot of
severity.
sense. Right, that does make a lot of sense, that why would I want to pay an extra amount by causing a default myself. Also, as you mentioned about the compounding guidelines that got updated last year in 2024, has it changed the way it impacts business, or how is it being looked at?
The compounding means, one is that the compounding is not the once you have already made the payment and cured the default, then there is no question of prosecution. When there is no question of prosecution, there is no question of compounding. Compounding happens when there's I'm in default, I'm in arrears, I'm in default, and the prosecution is imminent. Now the situation has already changed. The Supreme Court passed some judgment in Madhumilan syntax. They said even that delayed payment results into prosecution. Now those days were over, and that is no more a good law. And the law has also moved and changed because the time has changed, the economy has progressed. So now, in case you have made the payment, and in case you cure the default, there is no question of prosecution. So there is no question of even compounding. Why to even go for the compounding? Of course, there could be some pressure from the department side that you compound it, because otherwise we will prosecute. Now, in my understanding and my suggestion, which I believe is the correct one, is that there is no requirement of even compounding. One can go to the court and get the things quashed.
Right. So when a notice is issued against a company, what would your suggestion be? What should the first 10 days look like? What was the first step that the company or the individuals in the management should take, rather like what would be a very judicial approach to this?
You mean to say that the first reaction from the company side when they receive the notice? So,
Right. What is the action should be like?
so one is that they should immediately, in case they receive the notice, so one is that they have to look at the compliance record, and everything is compliant, nothing is unreported, and everything is reported, and they are confident. They should immediately consult their lawyer or chartered accountant or whomsoever they want to consult, and they should take a very cautious approach in that matter, and they should represent themselves well, because the first stage starts always with the person who's person responsible. That is the modus operandi. So they issue the first notice of 235. Rather, they should first go to 201, where they say that in case there is a default or not. In case there is a default, so first they have to ascertain the default. Then thereafter the ascertainment of the default, they should go to who is the person responsible for undertaking the compliance. And once they have decided, then they should move forward. But it is actually, the process is quite a number of times inverted. Actually,
Right.
a horse is put before the cart.
Right. I would love for both of you to give our audience some insights on the, let's say, maybe 4 or 5 control mechanism or system in place that would safeguard them, like help the company safeguard from uh, unintentional defaults. Like, what are some practices? What are some of the good practices that these companies or the founders should have? Vivek sir can go ahead and then followed by Mr. Shreyas.
See that the quarterly return should be filed. The money should be deposited at least subsequent 7th of subsequent month, which is the date fixed under Rule 30. So one should go by that. Quarterly return should be filed, and the final return, which is where the some additional time is given, that is also taken care, which is the after the end of the financial year, after 31st March of the every year, then you can file it. There is a additional time to file the return that should be taken care of, and there should be one person responsible for making the payment of TDS, because why the person should be responsible and the entire team should be geared up for this, because a company which is doing a reasonably good business, they have a lot of transactions, either in terms of making the payment to the employees, to the service providers, in the purchase of the goods, where the TCS is the one of the issues. So that is the that is the only recommendation, that they should see it very seriously, and no default should go beyond 60 days time.
Right. So I think keeping these timelines in mind is very crucial while we are approaching how to safeguard themselves or the company from a situation like this. Uh, how would you like to add to this, Mr. Shir?
I would add to this. See, most of the times the default, they are cash flow issues, right? And nobody really wants to default in these payments. These are statutory obligations that everybody wants to comply with. So I would recommend, obviously, that budgeting and financial planning is the only the other consideration from a commercial perspective which the businesses should look into. And what happens is that at times, while there could be other payment obligations which could be avoided, we try and avoid statutory obligations, just so that we are able to gain some advantage there. So my recommendation would be that statutory compliances should be looked at first, and planning should be in such a manner that you do not have to come across the situation at all. As simple as that. So prioritizing these payments is the basic principle that needs to be followed. That's it.
Right, and as Sir has mentioned, that it's very important to have a dedicated person appointed for entirely this purpose, because this might not look grave, but this can result in something which is very grave, and adversely affect the reputation of the company. And you both have been leading experts in this field. Do you think that the India is approaching towards decriminalizing it anytime soon, or what does it look like in the future?
So my take on this is that it should be surely decriminalized. So once you are compensated for delayed payment, you recover the interest, on the principal, on the commercial principle, and then there is no requirement of any prosecution. You should be having very much clarity in the entire system or the legislative framework, that only in case you have defaulted or you are continuing to be in default, and in that situation you can be prosecuted. That's all, because today the language of the provisions are not very clear, and the guidelines which they are issued from time to time is also not very clear. So the guidelines are, one guidelines issued after another issued, the one supersedes the another one, and something is changed and amendments were made. So in those circumstances, there is no clarity. There has to be some principle of master circular or the guidelines or instruction by the board, that what should happen in what circumstances.
Yes, right. That is true that it's very complex, that it's for a layman to understand the repercussions of this. The process is very tedious, which is where a professional is highly required in a scenario like this. What is the one reform that you would love to see in this landscape, along with maybe bringing in some clarity rather than it being so ambiguous?
In my personal view is that rather 276 capital B should be very much clarified, and they should very clearly lay down that only in case after the proceedings of 201 and 221 you are still in default in making the payment to the central government of the TDS amount deducted by you, then only this prosecution is possible. That
Right.
should be the clarity in 276 capital B.
That makes sense. I mean, I am completely aligned with what you mentioned. I would also love to hear Mr. Shreyash's take on this.
So obviously, as Vivek sir pointed out, delay is not itself, a ground, and only when there is a default, a clear default that I've not paid the amount, that prosecutions should happen. And as we discussed earlier, that criminal breach happens when I have collected the amount and I've not deposited it. Obviously, there's a default, right? A mere delay should not be penalized. Mere delay should not be treated in such a manner that there cannot be any correction or rectification of that default. Other than that, I think as Vivek sir pointed out, there is a change in government attitude as well towards prosecution. There are other laws as well which are looked at from a perspective of decriminalizing the same. We have seen a lot of provisions being looked at under the Companies Act itself to decriminalize those non-compliances. We are also looking at other legislations in terms of negotiable instruments, other specialized legislations under Insecticides Act, Fertilizers Act, and various other legislations. We are seeing some sort of approach where compounding is preferred over prosecution. So I think this is the route to go, and this also helps that ease of doing business aspect, and
Right.
businesses be more compliant. Once a business has seen that yes, there is a default and they've compounded, they're sure to follow the law more rigidly and stringently in the next further doing the business, and they're less likely to make those defaults. So I think that should be the approach.
Right, that is absolutely true, and I believe that the way over the last half an hour or 45 minutes you both have simplified such an issue, it's absolutely something that I couldn't have imagined, because a lot of people do not understand the technicalities that comes with it. It just sounds very alarming to know that this can result in criminal prosecution without knowing, how to navigate the situation. And I think we have simplified it enough for people even who are from a non-legal background to understand that this is not something that can be taken lightly, even though it comes off as something which is like a routine compliance task, but a default would indeed have consequences which can result in criminal prosecution, and it's not just a mere default or compliance issue. It can be way more grave. But having said that, we also realize that this is not something which is not manageable. It can be easily manageable with the right framework, right set of people, and a little mindfulness, is what I understood from our discussion today. This was extremely insightful for me and the audience. Thank you so much for joining us. If you find this relevant, please do share with your finance and compliance team, now that you know that this is so important and it's not something that can be taken lightly at all. And very a very huge thanks to both of you for joining us and helping us understand the importance of such an important regulatory compliance.
Thank you, Swagata. Thank you, Swagata, for your time and having us here with you. Thank you so much.
All
Thank you.
right, stay compliant, stay informed, and we will be joining in the next episode with more topics which are pertinent to the business. Thank you so much.